May it please the court, my name is Valerie Lennon and I represent the appellant Mesac Damas. Just briefly, the facts of the case: Mr. Damas pled guilty to the capital homicide of his wife and 5 children. He also at one point asked the court to represent himself, which the court denied. He then waived a penalty phase jury, allowing the trial judge in this case to determine his sentence.
Can I ask, in your brief, there is no statement of the facts concerning Mr. Damas's mental state. So am I correct that you do not take issue with any, aside from the Ferretta hearing and what you've raised, any of the factual findings of the trial court concerning your client's competency, any mental illness, that you have not challenged that?
I do not challenge that today, Your Honor. After, obviously, following the penalty phase, the trial judge did sentence him to death. Before the court today are 2 issues, none of them are mental health, or excuse me, 3 issues. The first is the Ferretta inquiry, whether the trial court erred by denying Mr. Damas' request to represent himself. Second, whether the trial court improperly doubled aggravators that both relied upon the age of the 5 child victims.
You would agree, even if we didn't find, even if we agreed that that they were improperly doubled, which doesn't seem that they were, that this is with 6 deaths and multiple aggravators, that it's beyond harmless, beyond a reasonable doubt. But even so, it seems that they do have elements that the other has, correct?
I would start by saying that this is a difficult case for everyone. We're in a unique situation here. I understand the harmless error test. We're in a unique situation where a jury did not make a recommendation, a unanimous recommendation, on Mr. Damas's.
But you're not challenging his waiver. You're not saying, I mean, because this was tried after Hearst, that if he had known, he made a decision, and you're not challenging his informed decision to waive penalty phase, waive mitigation, and to go before the judge.
No, Your Honor, I'm not challenging that today. I do challenge the legal reasoning behind denying his request for self-representation. So the reasoning behind that the trial judge denied it, was that he failed to, for 2 reasons. He failed to adequately answer the questions, and he failed to demonstrate a sufficient understanding of the legal process. Well, according to Ferretta and also Florida Rule of Criminal Procedure 3.111D3, there are only 3 requirements. The first being that he make an unequivocal request to dismiss his counsel. The second, that it be knowing and voluntary. And then the third is that he not suffer from any severe mental illness.
The rule of procedure you just cited, subsection 2, aside from the fact that he waives counsel, the court is required to conduct an inquiry. He says a thorough inquiry has been made into the accused's comprehension of that offer and offer to waive, offer of counsel, that is, and the accused's capacity to make a knowing, intelligent waiver. In this instance, I understand your position that the court may not have correctly considered the fact that he doesn't have the legal skills to conduct a trial. However, the court did conduct an extensive colloquy regarding the Ferretta issue, page after page of transcript, and your client seemed to have been combative, and to the point that he argued with the court, he interrupted the court, and so on and on. And isn't the record, the transcript, the colloquy that was conducted during the Ferretta waiver, isn't that sufficient to demonstrate that the court was convinced that he did not have, was not willing to offer whatever the court needed to hear to accept the fact that he was knowingly and intelligently waiving the right to counsel? I mean, what else did the court need to do other than continue with the rant, so to speak?
To say that the colloquy was thorough is correct. Maybe from Mr. Damas' perspective, it was a lot of questions, and all he was trying to say was, I just want to do this myself. I want to say what I have to say before Judge Grider. I don't want my counsel. That's it. So again, from the perspective of someone who is not, English is not his native language, who was not raised in the United States, it might have seemed a little weird. So looking at it from the defendant's perspective, I would ask you to do that in that regard. Mr. Damas bears the personal consequences of his crime. He bears the personal consequences of going before the judge, of representing himself before the judge, and that's what Ferretta says. It's not on the lawyers, it's not on the judge, it's on Mr. Damas himself, and he should have been allowed to do
But
that.
in
Was
this
there a competency or any mental health evaluation done of him prior to his Ferretta case, inquiry? When was that competency done in relationship to Ferretta?
So I believe there were several mental or competency evaluations done in this case.
Now, the first one, was he found incompetent?
Yes, and then he was restored or determined to
20
be competent
days.
within 20 days, yes.
So, and when was that determination made?
That date I don't know. I know in connection with the Ferretta inquiry, he originally requested it in July, and Ms. Martin will correct me if I don't have these dates right. In July, there was a competency evaluation done in August, and he was found competent to enter the plea, and the judge accepted that competency evaluation.
And that was prior to Ferretta? Or,
in September.
I mean, Ferretta was prior to that.
So I believe he made the first request in July of 2017. The competency evaluation was in August of 2017, and then the actual Ferretta hearing, I believe, was September 5th of 2017.
In Ferretta, we normally think of, and it's always, from my point of view, never wise for a defendant to represent himself or herself, but I agree that's a constitutional right. But in a case where the defendant has pled guilty, and where the defendant has waived mitigation, and where the defendant, I assume, had the right to address the court, to tell the court what he wanted, where does Ferretta come in? In other words, if there wasn't that lawyer there, and maybe this has never been addressed, but it seems to me that in this case, there would have been zero, there was nothing else, he didn't have witnesses to cross-examine, he didn't have an opening statement, he didn't have a sentencing order that he didn't like. What was it that he didn't do that he could have done if the lawyer was not in the courtroom?
Well, it's hard to say, because there were actually a couple of witnesses at the sentencing hearing. There was some testimony taken. The lawyers were allowed to say what they believed the mitigation package would have shown, and they did consult with a cultural expert during the sentencing.
Well, he wanted to waive mitigation. You know what you would be arguing, and I must say this respectfully, knowing that this is, as you said, a difficult case, what they would have been arguing down the road is that the judge didn't consider all the mitigation anywhere in the record. So when a defendant in a death penalty case, where they pled guilty, waives mitigation under Mohammed and every other case, the judge has this obligation, either through the state, but certainly the attorney, to see what mitigation there is, because this defendant could be a big malingerer, or he could be a seriously mentally ill individual, and that judge has that very important duty to determine it. So I just, in this case, am trying to understand what you would be asking for. It would be a new what? That would go back, what would on...
A new sentencing hearing where it's just Mr. Damas, and he's allowed to say to the court whatever he wants.
Does he want to die? Has he expressed that he wants the death penalty?
It's not really clear from the record. I mean, it does certainly suggest that at that point in time, but he doesn't come right out and say, I volunteer. So it's not entirely clear. I wouldn't call him a volunteer based on the record before us. So it's just really hard to say how that sentencing hearing would have turned out if there weren't the cultural expert, if the attorneys weren't saying, we believe the mitigation would have shown this or that. I would ask the court to just be mindful in this case that it was Judge Grider alone, with no jury, that sentenced Mr. Damas. So normally where the harmless error test would have been applied, we do have the unique situation where we could send it back to Judge Grider and let her make a new determination on either one of these issues. or all three of them. I would like to stand on the brief for that third issue today. The second issue, both regarding the 5 child victims, not regarding the wife. 2 of the aggravators rely solely on the tender age of the victim, those being that the victim was under 12 years of age and that the defendant was in a position of familial or custodial authority over the children.
I struggle to see why the familial or custodial relationship depends solely on age, because you certainly can have a circumstance where there is no relationship and you still have the age of the child. That those seem completely separate and not, it seems not solely dependent on age. So
But
I struggle to see your point, I guess.
looking at the statute and its average context, certainly there would be some unusual cases where the defendant would be in custodial authority over adult. But in the general sense of that statute, looking at it in its generic form, it's going to be a child under the age of 18. In order to have familial custody over the person in the first place, it's generally going to be someone under the age of 18. So here we have 5 victims under the age of 12. So that goes into play with, I believe it's sub L and sub M. It's both based on their vulnerability because of their age. And the proper remedy for that would be to remand it and ask the prosecutor to choose which one of those apply. And if there are no further questions from the court, may I reserve the rest of my time for rebuttal?
Of course.
Thank you.
May it please the court, my name is Lisa Martin. I represent the state of Florida in this matter. I would first like to say that the state asserts that the first issue, Feretta, has been waived. Mr.
Just
Damas.
speak up also.
Sorry?
Needs to speak up
Okay,
into the mic.
okay. The first issue has been waived. Mr. Damas pled. He specifically waived his right to appeal matters relating to the judgment and sentence. This Feretta order was not even a dispositive order, and the defense has not cited anything that says that he may not waive his appellate rights. Further, I believe that he waived the Feretta issue because he expressed satisfaction with his attorney during his plea colloquy, and when he first had this Feretta hearing, he was before Judge Hart, not Judge Grider. Judge Hart was replaced by Judge Grider on September 1st, just before he was supposed to go to trial on September 5th. When he got in front of a new judge, had he truly wanted to represent himself, he would have renewed this request with the new judge. It's a clean slate, starting over. However, he didn't. What he did was express his desire to plea and not go to trial, and he expressed satisfaction in his counsel. As to the Feretta inquiry, it was a full and complete Feretta inquiry. The defendant would have a right to represent himself where he can make a knowing and intelligent waiver. The trial court found that he was not able to do so because he was not responding appropriately to the inquiry. He kept repeating that he doesn't have a lawyer. He has a special lawyer that the court didn't know about. He misstated the number of years that it had been since the murders. He said that it was 5 years when it had been 8 years. So he was not able to show that he was making a knowing and intelligent waiver of his right to counsel. Therefore, the trial court correctly denied his request for self-representation. As to the improper doubling, the victim under 12 aggravator is solely based on age. However, the particular vulnerability based on the familial or custodial authority is based on the victim's relationship with the defendant. The defendant had authority and control over the victim, and that is what made them especially vulnerable. This is a case that is undoubtedly one of the most aggravated and least mitigated cases before the court. The trial court found 5 aggravators. The trial court found them to all be with great weight. The trial court found that each one was sufficient for the imposition of the death penalty. The mitigation that was proffered or argued was only found to be with some or little weight. There was only one non-statutory mitigator that was found to be with moderate weight, and that was based on Mr. Damas's childhood in Haiti and his abandonment or neglect by his parents when he was a child. Other than that, there was no mitigator found with great weight, and this court has found many other cases with fewer victims, less brutal crimes, with more mitigation that were still sufficient for the imposition of the death penalty. If there are no questions, the state would ask you to affirm the judgment and sentence.
May it please the court. Just briefly, Your Honors, the appeal waiver that the state is referring to is in about 8-point font. In the plea agreement, it was not covered in the plea colloquy, not even mentioned. So given that we're not even allowed to file Anders briefs in death penalty cases because Florida statute and Florida Constitution requires an appeal, I would ask the court to not enforce the appeal waiver in this case. There's also not a requirement anywhere in the decisional law that he renew that request on the eve of trial and before a new judge. So if there are no further questions, we would ask the court to reverse. Thank you.
We thank you both for your arguments. The court will now stand in recess for about 10 minutes.